Let's start. This is an appeal against the judgment and order of remand passed in title appeal number 6 of 2010, dated 10th November 2010 by the learned additional district judge Rampurhat Birbhum. By passing the impugned judgment, the learned judge in first appellate court set aside the judgment and decree of dismissal of title suit number 219 of 2005 passed by the learned civil judge within bracket junior division first court Rampurhat Birbhum. The learned judge remanded the suit back to the trial court with a direction to decide an issue as to whether the defendant had sublet the suit shop room in favor of defendant number 2 or not. Para. On the basis of the pleadings of the parties, the learned trial court framed as many as 7 issues and dismissed the suit on contest. The appellants preferred an appeal before the court of the learned additional district judge Rampurhat at Birbhum, being title appeal number 36 of 2008. The learned first appellate court was pleased to set aside the judgment and decree of dismissal passed by the trial court, framed 2 issues. Viz. Is the suit premises required for the reasonable requirement for the plaintiffs? I am in opinion in this case the balance between the plaintiffs and defendants should be observed. The plaintiff's sons are educated and healthy persons. They can find their job anywhere. On the other hand, if at this stage the defendant number 1 be weighted them, she will be destitute, which law does not permit. Para. Considering the materials and real picture, I am in opinion that the defendant number 1 should not be evicted, being aggrieved by and dissatisfied with the said judgment and decree of dismissal of the suit. The plaintiffs preferred title appeal number 6 of 2010 before the learned additional district judge Rampurhat Birbhum. Unfortunately enough, the learned additional district judge proceeded absolutely in a wrong direction. Though there is no pleading whatsoever regarding subletting of the suit premises, the learned judge in first appellate court learned framed one issue as hereunder. Is the suit premises is subletted within bracket SIC by defendant number 1 to defendant number 2 on plain reading of the impugned judgment passed by the learned additional district judge at Birbhum? It appears to me that the learned additional district judge probably was not aware of the principle as to when and how the issues are raised. It is needless to say that when a fact is asserted by one party and denied by other, issues or fact are raised, the object of framing issues is not focused upon questions on which evidence has to be laid and to indicate the party on whom the burden of proof lies. Framing of issues in regular civil suit is the mandatory requirement of law. In Sri G.V. Temple versus M.A. reported in within bracket 2015 3 SCC 624, it is held by the Honorable Supreme Court that the obligation and duty to frame issues is cast solely on the court, which may nevertheless elicit suggestions from the litigating adversaries before it issues settled by the court under Order 14 of the Code of Civil Procedure constitute the crystallization of the conflict or the distillation of the dispute between the parties to the lease, and are in the nature of disputed questions of fact and of or law. While discharging this primary function, the court is expected to peruse the pleadings of the parties in order to extract their essence, analyze the allegations of the parties, the contents of the documents produced by them, and thereafter proceed to frame the issues when the plaintiff did not allege in the plaint any case as to subletting against the defendant number 1. No issue can be framed on the basis of the statement made by the defendant number 1 in her written statement para. A copy of this judgment duly considering countersigned by the assistant registrar within bracket court be sent to the learned registrar, Judicial Service, High Court, Calcutta, requesting him to serve a copy of this judgment for service upon the concerned learned judge. A copy of this judgment be also sent to the learned judicial officers of the state with a view to appraising them about the basic considerations to be made while deciding a suit for eviction on the ground of reasonable requirement. A copy of this judgment along with lower court record be sent to the court of the learned additional district judge Rampurhat, Birbhum, along with lower court record for strict compliance of the direction passed by this court para. Urgent photostat copy of this order, if applied for, be supplied to the parties subject to compliance with all requisite formalities. Para. The writ petitioner claims to have been appointed as assistant teacher of Chakmundala Primary School under Rampurhat West Circle by the then President of Ad hoc Committee, District School Board, Birbhum, on 3rd January 1983. It has also been claimed by the petitioner that he had already completed B.A. degree in the year 1981 prior to his joining to the said school. It is stated that the chairman, Birbhum District Primary School Council, issued an order in respect of Rampurhat South Circle Bhaidi Memo number 831 within bracket 28 dated 26th July 2005, and thereby published a panel of head teacher in different schools with an information to the empaneled head teacher to join the school within 30 days from the date of order and to submit a report to the concerned sub-inspector of schools. The petitioner was enlisted in the said panel under serial number 7, and the petitioner was promoted as head teacher for Bargachia Prathomik School under Rampurhat South Circle. In pursuance of the said panel dated 26th July 2005, the petitioner submitted his joining letter on 17th August 2005 as head teacher, which has been duly recognized by the then head teacher in charge of the school. The said joining letter has been annexed as Annexure P3 to this writ petition. It has been stated by the petitioner that while the petitioner was appointed in the year 1983 at the relevant time. West Bengal Primary Education Act 1973 was in vogue, but no rule at that point of time was framed under the said act. The rule has been framed only in the year 1991. Before 1991 rule came into effect, 1940 rule was governing the field. It has been stated that the petitioner completed his B.A. degree prior to his appointment in 1983, and in terms of Department Memo number 306 SC/P dated 7th February 1967, the Director of Public Education, West Bengal, declared that there would not be any objection to treat the MA, BA, PGBT teachers of aided primary schools as A category teachers for the purpose of payment of government grants on deficit basis. The petitioner was served with a copy of the memo being number 3068 dated 11th November 2014 by Birbhum District Primary School Council, addressed to the Sub-Inspector of Schools, Rampurhat South Circle. By the said order, the council held that B.Ed degree cannot be considered for appointment of head teacher from the panel in terms of memo number 1920 dated 2nd September 2014. It was indicated that the Sub-Inspector of Schools overlooked the training qualification and made wrong entry in the head teacher panel. Therefore, the teacher was directed to be degraded from head teacher to assistant teacher, and overdrawn amount should be refunded. The said order of the District Primary School Council, Birbhum, is under challenge. In this writ petition, the petitioner has prayed for a writ of mandamus commanding the respondent authorities, particularly the respondent number 4, Chairman, Birbhum District Primary School Council, to act as per the panel prepared in terms of the letter by the memo number 831 within bracket 28 dated 26th July 2005 by withdrawing the impugned memo dated 11th November 2014 issued by the Birbhum District Primary School Council panel. In support of the case made out by the petitioner, the learned advocate appearing for the petitioner placed reliance in the case of B. Ghosh and others versus State of West Bengal and orders, an unreported decision decided on 1st September 2014 by a Honorable Division Bench of this Court Para 2607/2005 within bracket Annexure P2 page 26 of the writ petition. The petitioner was placed in the panel of head teacher and was sent to Bargachia Primary School 1708/2005 within bracket Annexure P3 page 27 of the writ petition. The petitioner joined as head teacher at the transferred place, namely Bargachia Primary School 11/11/2014 within bracket order impugned Annexure P4 page 28 of the writ petition, a memo which was issued by the Chairman, District Primary School Council, Birbhum, directing the Sub-Inspector of Schools, Rampurhat, to the effect that the teacher with B.Ed degree cannot be considered for appointment of head teacher from the panel. Accordingly, the petitioner was degraded from head teacher to assistant teacher and directed to return the purported overdrawal amount per. In the present case, the petitioner was appointed as an assistant teacher in 1983. having his requisite qualification according to the aforesaid rules, the petitioner was B.Ed on the date of appointment as an assistant teacher from the above rule. It does not appear that training qualification is mandatory for being appointed as head teacher. However, the petitioner had B.Ed qualification at the time of his appointment. In this case, if we take into consideration of memo being number 306/AC/P dated 7th February 1967 issued by the Director of Public Instruction, West Bengal, it transpires that the said Director of Public Instruction, West Bengal, declared that there may not be any objection to treat MA, BA, PGBT teachers of aided primary school as A category teachers for the purpose of payment of government grants. Subsequently, a clarification memo being number 352/AC within bracket PRY dated 31st May 1996 was issued from the end of the Joint Secretary to the Government of West Bengal, and in paragraph 4 whereof it has been clarified that cases already decided on the basis of the memo number 306/AC/P dated 7th February 1967 and the DPI West Bengal need not be reopened. It has been also mentioned that the cases of the primary school teachers who have obtained BT, B.Ed, PGBT degree diploma before 01/07/2006 may be decided in terms of the said memo dated 7th February 1967 by the DPI West Bengal. The said clarification memo has been annexed by the petitioner in his written notes of submission. Therefore, it transpires that teachers appointed prior to 01/07/1996, which clearly shows the petitioner is entitled to A category of pay scale and training qualification. B.Ed is not excluded. Therefore, if it is not in dispute that the petitioner's case has to be considered in the perspective of 1940 rules, then he is entitled to have A category scale and he was entitled to be included in the panel of head teacher. The submission made on behalf of the council that his name was wrongly included in the panel of head teacher is without any substance. The petitioners transferred to Bargachia Primary School in August 2005. He functioned as head teacher in the said school before he was superannuated from his service on and from 31/08/2015, but by the order impugned passed on 11th November 2014, the concerned Birbhum District Primary School Council degraded him from the post of head teacher to assistant teacher and directed refund of overdrawal amount drawn by him in his capacity as head teacher if the petitioner had requisite qualification according to the aforesaid rules. Question of overdrawal does not rise. Consequently, order of refund cannot be sustained as held by the Honorable Supreme Court in the case of State of Punjab within bracket Supra. The overall overdrawal cannot be insisted if a person comes within the category mentioned in the said judgment under paragraph 18. Petitioner qualifies the category number 4 under the said paragraph 18 of the said judgment, where the teacher has discharged his duties of a higher post and has been paid accordingly. According to the council, the petitioner was wrongly given appointment as a head teacher. Therefore, the entire amount he has drawn should be refunded. But in view of the aforesaid judgment, the same cannot be done because the petitioner has discharged his duties as head teacher, and those apart nothing transpires from the record that the petitioner was at fault in getting the order of appointment as head teacher. Therefore, the petitioner is entitled to pay of A category scale as also to the post of head teacher. Thank you.